I don't know how I can follow that with something about public comments. Hopefully you won't find it too dry. But my name's Debbie Harper, and I came here to talk about having public comments put back as an agenda item on the Commissioner's Court. So I want to talk about the difference between the comments that are made right now at Commissioner's Courts. Back in about 2019, the Texas legislature decided to allow people who wanted to make a comment on agenda items to be able to come and say something before the commissioners take a vote on each agenda item, which was really a good idea because before that time you couldn't do it. You'd come in and it would say you can comment on anything that is not on the agenda. Well, when they made that kind of a change, at some point the Commissioner's Court decided to get rid of the public comment agenda item, which had been previously in at least two other judgeships that I know of before that, with Walter Maynard and then with Judge Mike Ford. And even for part of the time, and that's part of the handout that I have there, one of them is an agenda item from Danny Chambers in 2015 after he'd become judge in 2014. So it used to be on the agenda where you could do a public comment. It's not required to do it. It's not mandatory to have public comments. However, every other government entity in Somervell County has public comments. Glen Rose City Council, the Appraisal District, Somervell County Hospital District, and the school board. And so it's not something that people just got rid of because they made that change in 2019. And I think that it shows a lot of respect for people to be able to go and make short, rule-oriented comments that maybe only last for 3 minutes or 2 minutes. It's up to the particular court to decide what rules they would like to have to limit it so that it doesn't become like a protracted, here I am for an hour. One of the things that John Cornyn had said about it, and I have that in the handout. I'm not going to read what he said except to say that he compared it to an open mic. So if you think about it that way, that if you went to a comedy club or karaoke or something else and you want to go up to the mic and say something that you would like to say, then you can do it. Now somebody on the Commissioner's Court has said before that he thought that, I shouldn't say he, I should say they said, but now the game is up, that it was a waste of time to allow people to do an open comment and that people might rant. So I want to address those two things in particular. One of them is it a waste of time to hear from the public? We're taxpayers, every one of us that live in Somervell County, and maybe you have something that came up over the weekend that you'd like to bring to the court, and of course we can all talk to our commissioners. I have commissioners that are sitting up there that I like very much, and I probably talk to them too much sometimes, but I really like them and admire them and respect them. But because there is another way to do it with public comments, and again, it's something that every government entity has said is fine, I think that should be part of the agenda. That you could come up and something happens on a Sunday or a Saturday and you didn't have time to have it put on the agenda as a regular agenda item, you still get to speak your mind. Now, and sometimes people specifically ask to be on the agenda. We know this because of the city administrator, Troy Hill, that came here recently, and I think the mayor has done that as well. People come and they want to say their say, but an agenda item is something different than a public comment. So, I want to talk about the rules for a minute. There's rules that the commissioners can make, and every entity does this. And they all kind of differ a little bit, but they're mainly the same. You can talk for 2 minutes or 3 minutes. City Council has something for decorum rules. This is what we expect out of people that come and do, public comments. We don't want them attacking and defaming people in the audience, for example. But then suppose somebody does rant. Suppose there is a rant. And I would say, from my point of view, sometimes rants are in the ear of the beholder. And somebody can say, well, that's a rant. But if somebody's excited a little bit and maybe a little bit emotional, as long as they're not like screaming or going on for 20 minutes about something, I don't consider that a rant. And if somebody starts to do something that looks like it's getting out of control, boom, there's a timer. And you're done. So I think that the rules are kind of cover that type of thing. And it might even be that nobody does a public comment. I've been to plenty of meetings here where nobody said anything. You know, nobody had something they wanted to say. However, they had the opportunity to do it if they wanted to. So I'm going to read something specific from the Texas Open Meetings Act. So number 1, a government body may not prohibit public criticism of the governmental body, including criticism of any act, omission, policy, procedure, program, or service. This subsection does not apply to public criticism that is otherwise prohibited by law. Rules must be viewpoint neutral, but as the Supreme Court has said, giving offense is a viewpoint because you can't determine whether or not something's going to be offensive to somebody else. That's freedom of speech. Public criticism that is otherwise prohibited by law is a narrow exception. So that pretty much tells you what it is that you could talk about in a public comment session for your 2 or 3 minutes as determined by the court. So I'm going to give a couple of examples here, actually 3 examples. I remember back when in Judge Ford's administration, there was something that had to do with the golf course, and I forget exactly because I don't golf, but I believe it had something to do with trying to cut back the benefits for Somervell County residents to be able to use the golf course or get a discount or something like that. There was a ton of golfers that showed up to the commissioner's court that day to be able to make a comment. And I think that they should. If people wanted to come up and say something about it, I think they should have done it. I don't think it was on the agenda. There's also somebody I heard from a school board public comment recently where I listened to it, and the mother was concerned about the fact that her child had gone to the library and been put in front of a television instead of being allowed to read books. Now, I don't know. You know, you listen to comments, you don't know if that's somebody's opinion or if it's true, who knows. But the fact of the matter is that she was able to bring that up. Now, any government entity does not act on it, but they definitely are going to hear it. And I think, it's a good thing. The other thing is it a good idea for a matter of policy to have somebody with a criminal record that's in charge of payroll or managing the expo? And finally, as far as changing the agenda, somehow in all the other judge courts, there was never a prayer on the agenda. And I like that because I like secular government. But somebody decided to put prayer on the agenda. And so from the point that somebody can do this, the commissioner's court can decide to go and add an item to the agenda. And any commissioner could do it and say, this is what we would like to do to have a change. Or maybe they vote on it, But definitely it's not, my point is that agendas are not set in stone. They can be changed. So I respectfully ask the commissioners to put public comment on as a regular agenda item, and I thank you for your time.